And welcome back. Will Worsham joined us now for this week's Speaking Legal discussion. Good to see you again.
Yeah.
Good to be here.
You're dressed a little differently than last time I saw you.
Right, yeah.
Not wearing the gi or whatever it's called.
Right, no taekwondo today.
Are you ready for the question?
You bet.
All right, here we go. My son has children from his first marriage, and his fiance also has children. We like her, but want to make sure our inheritance goes to our grandchildren and doesn't get diverted. What's the best way to do that?
That's a good question.
Yeah, you know, and it's a question that comes up a lot these days, and whether you yourself are getting remarried, or in this situation, whether it's a child or children that are potentially getting remarried. It doesn't even have to be this situation. It can just be the thought of a future marriage where, you know, stuff might not go where you want it to go. And so, you know, we do solve that problem for people, and we do that with a trust. You know, a trust is one of the ways we do estate planning. In my opinion, it's the best way. It gives you the most flexibility. There's certainly other ways to do your estate planning, but a trust is one that's going to give us the most flexibility, particularly in areas where we're talking about asset protection, and that's what we're talking about here. So in a situation like this, what we would typically do is the settlors, that would be the people making the trust, we'd still make a revocable living trust for them. They can still change anything they want in their lifetime. It doesn't restrict their ability to access the assets. But what we would do is we would create a situation to where when those assets are passed on to, in this case, that particular son, we would pass them to him in an irrevocable trust. And so there'd be a third-party trustee. He would not have direct access to those assets. That trust can be set up any way we want it to. You know, it could hold all those assets in trust for his entire life and then distribute to the children, his children, and they could be children that are in existence at the time the trust is created, and they can include afterborn children as long as they're in his bloodline. Or anybody else. We can distribute that asset after his death to anybody we want. We could say that we will distribute those assets to him outright after 5 years. After 10 years, we can say we'll distribute those assets to him outright after he reaches the age of 45. We can do a lot of things with irrevocable trust.
You can eke it out over time.
You can eke it out. A third at 30, another third at 35, and the remainder at 40. We can be really creative with the way that we let those assets go and get to that person. But the key thing is, because he's not in direct control of those, a third-party trustee is the one that distributes those assets. And that means he can't go and demand them for any reason. A trustee, in their own discretion, is the one that gets to release those funds. And that can be a very broad grant of powers. So it can be, typically we'll say it's for their health, education, maintenance, and support. And that can be almost anything. So we might distribute the asset, the income from that trust outright during his life. So, you know, whatever it is, the income that those assets produce, he can have, they go outright. But the key is, because it's an irrevocable trust, creditors don't have access to it. Creditors are intentional and unintentional creditors. So I like to speak about an intentional creditor would be like Discover Card. You borrow that money, you know that. An unintentional creditor is a creditor you create by accident. No pun intended, but a car accident could create an unintentional creditor. A divorce can create an unintentional creditor.
But that keeps irrevocable, keeps them away.
That's correct. It never becomes a marital asset because it's held it's not owned. The principle of that irrevocable trust is not owned by that person. It's in the control of a third-party trustee.
Let me ask what may be a dumb question, but irrevocable, revocable. Say I make an irrevocable trust.
Yes.
Once it's down and signed, can I change it?
For the most part, you cannot.
Okay, that's what I want to be sure of.
Makes some people afraid to do one because they think it's a done deal. But if it's a revocable, it's changeable.
And this is revocable. The scenario we're describing here is a revocable trust as long as the settlors, the people that make the trust, are alive. It doesn't become irrevocable until they pass away and their son, in this case, becomes a beneficiary. And he can go to the trustee and say, I need $50,000 for a down payment on a house. And the trustee can go, health, education, maintenance, support. Yeah, okay. But they'll write that check to the closing company, the bank, or the seller. They won't write it
to the son.
Not to the son.
Got it.
Right. I need a car. Anything they want. I need college education. It can be for those things. But,
so you're in control. You just need some good advice as to how to write this up and make sure it'll serve you the way you want it to. So if you have a legal question for Will, email him at wworsham@colorton.com. He'll answer your question on the show. Good one today. Thank you.
You bet.
Thanks, Will.
Okay, up next, Bruce Porter stops by with tips on how to keep your money secure when the markets seem kind of anything but.
Yeah, don't go away. Ozarks Live will be right back.